SFG Essential, Current Affairs, Polity 1. President's Rule, Article 356, News. President's Rule under Article 356 has recently been imposed in Manipur, soon after the CM of the state resigned. About Article 356 of the Indian Constitution. Article 356 of the Indian Constitution pertains to the imposition of President's rule over a certain state or union territory. It is derived from the Government of India Act of 1935. Grounds of Declaration of President's Rule. Article 356. If the President receives a report from the state's governor or is otherwise convinced or satisfied that the state's situation is such that the state government cannot carry on the governance according to the provisions of the Constitution. Article 365. As per this article, President's rule can be imposed if any state fails to comply with all directions given by the Union on matters it is empowered to. Parliamentary approval. Parliamentary approval is necessary for the imposition of President's rule in any state. Proclamation of President's rule should be approved in both houses of Parliament within 2 months of its issue. The approval is by a simple majority. President's rule is initially valid for 6 months. It can be extended up to 3 years with parliamentary approval every 6 months. The 44th Constitutional Amendment Act brought in some constraints on the imposition of the President's rule beyond a period of 1 year. It says that President's rule cannot be extended beyond 1 year unless there is a national emergency in India. Election Commission of India certifies that it is necessary to continue the President's rule in the state because of difficulties in conducting assembly elections in the state. President's rule can be extended for a max period of 3 years, beyond which constitutional amendment is required. Revocation of the President's rule. President's rule can be revoked any time after such a proclamation has been made by a subsequent proclamation by the President. A proclamation of revocation does not require approval by Parliament. 2. Losing membership of Parliament (MP) under Article 1014. News. A member of Parliament from Punjab has approached the Punjab and Haryana High Court, seeking permission to attend the ongoing parliamentary session. Citing Article 1014, the MP is concerned about the potential loss of membership due to prolonged absence from the House. Provisions of Article 101. Vacation of seats. Article 101 lays down the conditions under which a member of Parliament's seat may be vacated. No dual membership. Article 101. 1. A person cannot simultaneously be a member of both houses of Parliament. Article 101. 2. A person cannot be a member of both Parliament and a state legislature. If a member fails to resign from the state legislature within 14 days, their parliamentary seat is declared vacant. Article 101. 3 members may resign by submitting a handwritten letter to the Speaker, Lok Sabha, or Chairman, Rajya Sabha. The seat is vacated upon acceptance of the resignation. Prolonged absence. Article 1014. If an MP remains absent from all House meetings for 60 consecutive days without permission, the House has the authority to declare the seat vacant. The 60-day period does not include any time when the House is prorogued or adjourned for more than 4 consecutive days. Seeking leave. MPs anticipating prolonged absences can apply for leave through the Committee on Absence of Members from the sittings of the House. The committee reviews applications and makes recommendations, which the House then approves. Even if an MP exceeds 60 days of absence, the House must formally vote to declare the seat vacant. Notably, no MP's seat has ever been vacated under Article 1014 to date. 3. Article 22 of Indian Constitution. News. SC has recently ruled that the requirement under Article 22(1) of the Constitution to inform an arrested person about the grounds of arrest is not a formality, but a mandatory constitutional requirement, and failure to do so will render the arrest illegal. About Article 22. Article 22 of the Indian Constitution provides protection from and against arrest and detention in certain cases. These safeguards help in avoiding any miscarriage of justice by acting as a kind of check and balance on the powers of police officers making arrests and authorities empowered to detain a person. These safeguards are available to all people, irrespective of whether they are citizens of India or not. However, it cannot be availed by an enemy alien. These are applicable to all arrests, except those made under a warrant issued by the court. The offense can either be criminal or quasi-criminal in nature or any activity prejudicial to the interests of the state. However, these safeguards are not applicable to a person arrested or detained in a civil matter. 4. The Waqf Amendment Bill, 2025 News. Parliament has passed the Waqf Amendment Bill, 2025. Aim. The Waqf Amendment Bill 2025 aims to improve the management of Waqf properties by protecting heritage sites, supporting social welfare, and making the system more transparent. Waqf property, a Waqf, also known as ABS or mortmain property, is an inalienable charitable endowment established under Islamic law. It is a personal property given by Muslims for a specific purpose, religious, charitable, or for private purposes. Formation of Waqf. The Waqf can be formed through a deed, or instrument, or even orally. A property can be deemed to be Waqf if it has been used for religious or charitable purposes for a long period of time. Key changes introduced by the WACF Amendment Bill 2025 retention of WACF by user properties registered on or before user doctrine, and the law's enactment will retain their status unless future recognition they are disputed or identified as government land. However, the future recognition of WACF status requires documentary proof or declaration from a practicing Muslim of at least 5 years. WACF by user is a doctrine rooted in Islamic legal traditions that recognize properties as religious or charitable endowments based on their uninterrupted communal use, even in the absence of formal documentation. Inclusion 1. Non-Muslims will be appointed to key WACF institutions, including the Central WACF Council institutions, state WACF boards, and WACF tribunals. 2. Both the Central WACF Council and state WACF boards must include at least 2 non-Muslim members. Asterisk non-Muslims will remain a minority in both the council and the WACF boards. 3. The requirement that a WACF board's chief executive officer must be a Muslim has been removed. 4. State government representatives on the WACF board must be a joint secretary-level officer dealing with WACF matters. WACF tribunal and legal changes. 1. Tribunal composition. WACF tribunals will now have 3 members instead of 2. A. A district judge. B. A joint secretary-level state officer. C. An expert in Muslim law. 2. Appeals. Tribunal decisions can be challenged in the High Court within 90 days. Empowering the bill empowers senior government officers, government officials, above district collector rank, to settle disputes in property disputes over whether a property is WACF or government land, replacing the WACF tribunal's exclusive authority under the 1995 Act. Until the officer submits a report, disputed properties will be treated as government property. Application of Limitation Act to WACF properties. The Section 107 of the WACF Act, which had excluded WACF properties from the Limitation Act 1963, has been removed. With this deletion, the standard 12-year limitation for reclaiming encroached property will now apply to WACF land. Centralized digital registration of WACF properties. The bill mandates the creation of a digital portal for registering and updating WACF properties. Central government oversight. The Comptroller and Auditor General, CAG, will conduct audits. Separate WACF boards will be allowed for the BORA and Aga Khani Sex 5. Immigration and Foreigners Bill, 2025. News. The Union government recently introduced the Immigration and Foreigners Bill, 2025 in the Lok Sabha. About Immigration and Foreigners Bill, 2025. The bill repeals and replaces the Immigration, Carriers Liability Act, 2003 Pre-Independence Laws, the Passport, Entry into India Act, 1920, the Registration of Foreigners Act, 1939, and the Foreigners Act, 1946. Key provisions of the Immigration and Foreigners Bill, 2025. 1. National security measures. The bill prioritizes national security and sovereignty, barring entry or residence for any foreigner posing a threat to India's integrity. Immigration officers will have the authority to arrest suspects without a warrant if they are believed to be violating immigration laws. Additionally, all foreigners must register upon arrival, and their movements, name changes, and access to restricted areas may be monitored. 2. Stricter entry and stay regulations. All foreigners must have a valid passport and visa to enter or leave India. Institutions like educational establishments, hospitals, and nursing homes must report foreign nationals under their care to immigration authorities. Carriers, airlines, transport operators will be responsible for ensuring passengers have valid documents. If a foreigner is denied entry, the carrier must remove them immediately or face fines and possible seizure of their transport. 3. Severe penalties for violations entering without valid documents, up to 5 years in prison and a 5 rupees lakh fine. Using forged documents, 2 to 7 years in jail, with fines ranging from 1 rupee lakh to 10 rupees lakh. Overstaying or violating visa conditions, up to 3 years imprisonment and a 3 rupees lakh fine. Transporting foreigners without valid papers, 5 rupees lakh fine and potential seizure of the vehicle. Note: foreigners holding dual citizenship will be recognized as citizens of the country whose passport they used to enter India. 6. Domicile-based reservation. News. The Supreme Court recently ruled that domicile-based reservations for postgraduate medical seats are unconstitutional. About the SC ruling, Tanvi Bell v. Shrey Goel and others, 2025. Violation of equality. The Supreme Court held that domicile-based reservations for postgraduate medical courses violate Article 14, Right to Equality, of the Indian Constitution. Merit-based admissions. The court ruled that admissions to PG medical courses must be solely based on merit, determined through the National Eligibility Entrance Test, NEET. No impact on past admissions. The ruling will not affect admissions that have already been granted under domicile-based reservations. Domicile versus residence. The court clarified that domicile refers to a person's legal home and is different from residence, which is often misunderstood as temporary stay. India has only one domicile, the domicile of India, as defined under Article 5 of the Constitution. The concept of state-specific domicile is not legally valid under the Indian legal framework. 7. Conjugal rights. News. The Supreme Court has ruled that proceedings related to the restitution of conjugal rights, Section 9, Hindu Marriage Act, and maintenance, Section 125, CRPC, are independent of each other. A husband remains legally obligated to pay maintenance to his wife even if she refuses to comply with a court order for restitution of conjugal rights. About conjugal rights. Conjugal rights refer to the legal entitlements arising from marriage, allowing spouses to cohabit and share companionship. These rights are upheld and enforced through both personal laws and criminal law provisions governing maintenance and alimony, restitution of conjugal rights. A legal remedy allowing a spouse to seek a court decree compelling the other spouse to resume cohabitation. The aim is to prevent marital breakdown and encourage reconciliation. Judicial precedents. T. Saritha versus T. Venkatasubbiah, 1983. The Andhra Pradesh High Court struck down Section 9 of the Hindu Marriage Act, deeming it unconstitutional and a violation of individual freedom. Saroj Rani versus Sudarshan Kumar Chadha, 1980. The Supreme Court overturned the Andhra Pradesh HC ruling, upholding Section 9 as a means to prevent marital discord and promote reconciliation. 8. Right to access to justice not absolute. Supreme Court SC. News. Recognizing access to justice as a key pillar of democracy, the Supreme Court recently fined a petitioner for repeatedly filing baseless cases that strain the judicial system. Right to access to justice, it is a fundamental principle of the rule of law, ensuring individuals can seek remedies for grievances through formal or informal justice institutions. The Supreme Court, in Anita Kushwaha v. Pushab Sudan, 2016, ruled that access to justice is a fundamental right under Article 14, right to equality, and Article 21, right to life and personal liberty. Other provisions/mechanisms related to access to justice. Constitutional provisions. The preamble ensures social, economic, and political justice. Directive principles of state policy under Article 39A guarantee the right to free legal aid. Article 32, right to constitutional remedies, and Article 226, high courts. Power to issue writs, safeguard legal access. Public interest litigation PIL broaden locus standi to or organizations to file cases for enforcing rights, even if they are not directly affected. Legal framework. The Legal Services Authorities Act, 1987, established NALSA to provide free legal aid to weaker sections of society. 9. 80 hoc judges in High Court. News. The Supreme Court has relaxed its rule for appointing ad hoc judges in high courts to clear pending criminal cases. Now, ad hoc judges can be appointed even if vacancies are below 20% of the sanction strength. This 20% condition was originally set in the Lok Prahari v. Union of India case in April 2021. Supreme Court guidelines for appointment. Chief justices of high courts can recommend retired judges for appointment. Each high court may appoint 2 to 5 ad hoc judges, not exceeding 10% of its sanction strength. These judges will only hear criminal appeals in benches headed by a sitting high court judge. About ad hoc judges in high court. Ad hoc judges are temporary judges appointed to high courts to address case backlogs or fill vacancies when permanent judges are unavailable. Constitutional basis. Article 224A of the Indian Constitution allows the Chief Justice of a high court, with presidential approval and the consent of a retired judge, to appoint retired high court judges temporarily. Tenure. Ad hoc judges usually serve for 2 to 3 years. Salary and benefits. Same emoluments and allowances as permanent high court judges, excluding pension. 10. Lokpal of India. News. The Foundation Day of the Lokpal of India was held for the first time on January 16 at Manekshaw Center, New Delhi. About Lokpal. Statutory body. Lokpal and the Lokpal is established under the Lokyuktas Act, 2013. Mandate. To inquire into allegations of corruption against specific public functionaries and address related matters. Organizational structure. The Lokpal consists of a chairperson and 8 members, of whom 4 are judicial members. The chairperson should be either the former Chief Justice of India or former judge of the Supreme Court, eminent person, or in who fulfills the eligibility criteria as specified. The judicial member of the Lokpal should be either a former judge of the Supreme Court or a former Chief Justice of a high court. Note, at least 50% of the members must be from scheduled castes SC, scheduled tribes ST, other backward classes OBC, minorities, or women. Appointment of members. The chairperson and members are appointed by the President of India on the recommendation of a selection committee comprising the Prime Minister, chairperson, the Speaker of Lok Sabha, the Leader of Opposition in Lok Sabha, the Chief Justice of India or a judge nominated by him, her, and 1 eminent jurist. The term of office for Lokpal chairman and members is 5 years, or till the age of 70 years. The chairperson's salary, allowances, and service conditions are equivalent to those of the Chief Justice of India, while those of members are equivalent to Supreme Court judges. Jurisdiction. The Lokpal's jurisdiction extends to the Prime Minister, except on allegations of corruption relating to international relations, security, the public order, atomic energy, and space. Ministers of the Union Government, members of Parliament, and officials of Groups A, B, C, and D in the Union Government. Chairpersons, members, officers, and directors of boards, corporations, societies, trusts, or autonomous bodies established by Parliament or funded by the Union/state government. Societies, trusts, or bodies receiving foreign contributions above 10 rupees lakh. Powers of Lokpal. Supervisory authority over the CBI, including approving the transfer of investigating officers in referred cases. Authorization of CBI for search and seizure operations. Powers of a civil court for the purpose of any preliminary inquiry, the inquiry wing under the Code of Civil Procedure, 1908. Confiscation of assets and benefits obtained through corruption in special circumstances. Recommending the transfer or suspension of public servants involved in corruption allegations. Reporting. As per Section 48 of the Act, the Lokpal must submit an annual report on its activities to the President, who presents it to both houses of Parliament. 11. Comptroller and Auditor General, CAG. News. A recent report by the Comptroller and Auditor General, CAG, has revealed that over 33 Indian rupees crore was spent on the renovation of the then Delhi Chief Minister's residence.
About CAG.
It is the apex audit institution of India and serves as the guardian of the public purse. He heads the Indian Audit and Accounts Department. Article 148 of the Constitution provides for the appointment of the CAG by the President of India. The CAG holds office for a term of 6 years, or until the age of 65 years, whichever is earlier. He may resign at any time by submitting his resignation to the President. Independence of the office, security of tenure. The CAG can be removed by the President only by following the procedure outlined in the Constitution. Financial independence. The administrative expenses of the CAG's office are charged on the Consolidated Fund of India. No minister can represent the CAG in either House of Parliament, nor can any minister be held responsible for any actions taken by him. Duties and powers of the CAG. The CAG audits all expenditure from Consolidated Fund of India, the Consolidated Fund of each state, and of Union territories with a legislative assembly. Contingency Fund of India and of each state. Public Account of India and of each state. He audits the receipts and expenditures of both the central and state governments. Audit reports President. The CAG submits on central accounts to the who then places them before both houses of Parliament. The CAG also audits the accounts of all bodies and authorities substantially funded by central or state revenues, government companies, other corporations and authorities, when mandated by relevant legislation. Types of audits conducted by CAG. The CAG submits the following 3 audit reports to the President. Audit report on appropriation accounts, audit report on finance accounts. Audit report on public undertaking 12. D. Voters.
News.
Assam's opposition recently raised concerns over the plight of doubtful voters in Assam, demanding the closure of the state's only detention center, now termed a transit camp, and the tabling of the National Register of Citizens, NRC, report in the Assembly. About voters. Voters, or doubtful voters, are a category of voters in Assam who couldn't give evidence to prove their Indian nationality and whose cases are pending with the foreigners' tribunals or who have been declared foreigners by the tribunal. The devoter category was introduced by the Election Commission of India in 1997. Because their Indian citizenship has not been verified, doubtful voters are not allowed to vote in elections. They are also not permitted to run for office in the nation's elections. However, doubtful voter or doubtful citizenship have not been defined in the Citizenship Act 1955 or the Citizenship Rules of 2003. The Citizenship Rules, 2003, was framed under the provisions of the Citizenship Amendment Act, 2003. The rules framed in 2003 list out the steps to be followed for the preparation of the National Population Register, NPR, and the National Register of Indian Citizens, NRIC. The marking as a doubtful voter is a temporary measure and cannot be prolonged. Within a specific time frame, a decision needs to be made. According to the documentation provided, if it is determined that the individual is a foreign national or an illegal immigrant, they may be deported or placed in a detention center. Voters can also apply to have their names added to the NRC. They will be included only after they get clearance from the foreigners' tribunals, and their names are removed from electoral rolls under the D category. 13. National Commission for Safai Karamkaris, NCSK. News. The Union Cabinet has approved the extension of the tenure of the National Commission for Safai Karamkaris, NCSK, for another 3 years, up to March 2028. About the National Commission for Safai Karamkaris. Established as a statutory body in 1994 under the National Commission for Safai Karamkaris Act, 1993, the NCSK later became a non-statutory entity following the expiration of the Act in 2004. The Commission's role was further expanded with the introduction of the Prohibition of Employment as Manual Scavengers and their Rehabilitation Act, 2013. Organizational structure. NCSK operates under the Ministry of Social Justice and Empowerment as a non-statutory body. It consists of a chairperson, holding the rank and status of a Union Minister of State, a vice chairperson, equivalent in rank to a secretary to the Government of India, 5 members, including 1 female member, all holding the status of secretary to the Government of India, a secretary, equivalent in rank to a joint secretary to the Government of India, along with additional supporting staff. Key mandates of NCSK proposing specific action plans to the central government aimed at eliminating disparities in status, facilities, and opportunities for Safai Karamkaris. Reports central and state governments submitting to the regarding challenges or issues faced by Safai Karamkaris. Overseeing the implementation of the Prohibition of Employment as Manual Scavengers and their Rehabilitation Act, 2013. 14. Armed Forces Tribunal, AFT. News. The Supreme Court has proposed setting up Armed Forces Tribunal, AFT, benches in Jammu and Kashmir and Himachal Pradesh to address the rising backlog of defense-related cases. About Armed Forces Tribunal, AFT. Military Tribunal Armed Forces AFT is in India established under the Tribunal Act, 2007. It operates under the Ministry of Defense, MOD. Jurisdiction. To provide for the adjudication or trial of disputes and complaints with respect to commission, appointments, enrollment, and conditions of service in respect of persons subject to the Army Act, 1950, the Navy Act, 1957, and the Air Force Act, 1950. To provide for appeals arising out of orders, findings, or sentences of courts martial held under the said acts and for matters connected therewith or incidental thereto. The tribunal can also dismiss the appeal if the court martial findings are found to be justified. The tribunal can allow an appeal against conviction. The tribunal shall have power to grant bail to any person accused of an offense and in military custody, with or without any conditions which it considers necessary. An appeal against a tribunal's decision can be made only to the Supreme Court. Benches. Besides the principal bench in New Delhi, EFT has regional benches at Chandigarh, Lucknow, Kolkata, Guwahati, Chennai, Kochi, Mumbai, Jabalpur, Srinagar, and Jaipur composition. Judicial member administrative. Each bench comprises of a and an member. The judicial members are retired high court judges, and administrative members are retired members of the armed forces who have held the rank of Major General/equivalent or above for a period of 3 years or more. Judge Advocate General, JAG, who has held the appointment for at least 1 year, is also entitled to be appointed as the administrative member. Functioning. The tribunal shall transact their proceedings as per the Armed Forces Tribunal Procedure Rules, 2008. All proceedings in the tribunal will be in English. The tribunal will normally follow the procedure as is practiced in the High Courts of India. 15. Telecom Dispute Settlement and Appellate Tribunal, SAT. News. TDSAT has put on hold the telecom regulator's 141 Indian rupees crore penalty on Reliance Jio, Bharti Airtel, and Vodafone Idea for failing to control spam. About TDSAT. It was established by amending the TRAI Act of 1997 in the year 2000. Objective: to adjudicate disputes and hear appeals related to telecom, broadcasting, and information technology services in India. Composition equals it consists of 1 chairperson and 2 members, which are appointed by central government. Eligibility. Chairperson should be or should have been a judge of SC or Chief Justice of HC. Members should have held the post of Secretary to Government of India or equivalent post in state government for not less than 2 years period. Tenure. Chairperson of the tribunal shall hold office for a term of maximum 4 years or till the age of 70 years, whichever is earlier. Other members hold office for 4 years or till the age 65 years, whichever is earlier. Powers and jurisdictions. It exercises jurisdiction over telecom, broadcasting, IT, and airport tariff matters under the TRAI Act, 1997, the Information Technology Act, 2008, and the Airport Economic Regulatory Authority of India Act, 2008. It exercises original as well as appellate jurisdiction in regard to telecom, broadcasting, and airport tariff matters. In regard to cyber matters, the tribunal appellate exercises only the jurisdiction. In January 2004, the government included broadcasting and cable services also within the purview of TRAI Act. After coming into force of the relevant provisions of the Finance Act 2017, the jurisdiction of TDSAT stands extended to matters that lay before the Cyber Appellate Tribunal and also the Airport Economic Regulatory Authority Appellate Tribunal. Appeals from TDSAT can be filed in the Supreme Court of India. 16. Information Technology, IT, Act, 2000. News. Elon Musk-owned X, formerly Twitter, has challenged the government's use of Section 79(3)(b) of the Information Technology Act, 2000 IT Act to moderate and order the removal of content on social media. About Information Technology, IT, Act 2000. It is India's primary legislation governing cyber activities, electronic transactions, and digital governance. It establishes a legal framework for cybersecurity, digital signatures, data protection, and penalties for cyber offenses. Key features. It grants legal recognition to electronic records and digital signatures. It defines intermediary liabilities and protections. It empowers the central government and CERDIN to regulate cybersecurity. It was amended in 2008 and 2015 to address emerging cyber threats. Important provisions in news. Section 69A. It allows the government to block online content in the interest of sovereignty, national security, public order, or to prevent incitement. It requires written orders and follows procedural safeguards. It was upheld by the Supreme Court in Shreya Singhal v. Union of India, 2015. Section 79. It provides conditional immunity to intermediaries for third-party content. The provision is a safe harbor measure that exempts an intermediary from liability for information published on the platform by a third party, that is, users of the platform. As per Section 79(3)(b), intermediaries must remove unlawful content upon government notification to retain immunity. It does not authorize direct blocking but notifies intermediaries of potential liability. 17. National Anthem of India. News. Recently, a controversy in Tamil Nadu's Legislative Assembly occurred when the governor departed without delivering the customary address, citing the absence of the national anthem. About National Anthem of India composed by Rabindranath Tagore in Bangla. It was first adopted in its Hindi version by the Constituent Assembly on January 24, 1950. Procedure for singing the anthem. Full version duration, around 52 seconds. Occasions. The full version is sung during civil and military investitures. Arrival or departure of the president or governor at state functions. Parades or when the national flag is unfurled. Arrival or departure of the president for any public function. The anthem is preceded by a drum roll when performed by a band. Short version duration, around 20 seconds. Occasions, the short version is played during toasts and messes. On special occasions as directed by the Government of India, mass singing. Occasions, the anthem is sung at unfurling of the national flag. Cultural and ceremonial functions where there is public participation. Arrival or departure of the president at non-state public functions. Legal and constitutional aspects. Article 51A. The Constitution of India encourages every citizen to respect the national anthem as part of their fundamental duties. Punishment for non-compliance. In a 2019 case, the Madras High Court dismissed a petition seeking punishment for not playing the national anthem at a function, ruling that there is no legal mandate for its compulsory performance. 18. State Emblem of India. News. Union Home Ministry recently asked state governments to prevent the misuse and improper depiction of the state emblem of India, emphasizing that the lion capital logo is incomplete without the motto Satyameva Jayatin Devanagari script. About state emblem of India. It is an adaptation of the lion capital of Ashoka at Sarnath. In the original, there are 4 lions, mounted back-to-back, on a circular abacus, which itself rests on a bell-shaped lotus. The bell-shaped lotus has been omitted in the state emblem. The 4 lions symbolize power, courage, confidence, and faith. The base of the abacus has sculptures in high relief of an elephant, a galloping horse, a bull, and a lion separated by intervening dharma chakras. It was adopted on January 26, 1950. Below the representation of the lion capital, the words Satyameva Jayate are written in Devanagari script, which is also the national motto of India. The words are a quote from Mundaka Upanishad, the last and most philosophical of the 4 Vedas, and is translated as, "Truth alone triumphs." Use of State Emblem of India is restricted to the authorities/purposes specified in State Emblem of India, Prohibition of Improper Use, Act 2005 State Emblem of India, Regulation of Use, Rules 2007. To the point terms/initiatives in News Doctrine of Context. Recently, the Supreme Court, SC, highlighted the merger. Doctrine of Merger. About doctrine of merger, it is a legal principle that ensures only one binding decision exists for a case in the judicial system. When a higher court reviews and rules on a case, the lower court's decision merges with the superior court's ruling. This applies in cases of appeal, revision, or review, preventing confusion about which order is final and enforceable. The doctrine is not recognized statutorily, but is a statement of judicial propriety. It was explained in Kanhayam v. State of Kerala, 2000. Panchayat Se. Context. Lok Sabha Speaker has inaugurated Panchayat Parliament Se Parliament 2.0. 2.0. About Panchayat Se Parliament 2.0 objective. The primary aim is to empower elected women representatives from scheduled tribes in Panchayati Raj institutions, PRIs, by enhancing their knowledge of constitutional provisions, parliamentary procedures, and governance. Organized by National Commission for Women, NCW, in collaboration with the Lok Sabha Secretariat and the Ministry of Tribal Affairs. New student. Context. The Ministry of Home Affairs, MHA, has recently visas. Launched 2 special category visas for international students pursuing higher education in India. About new student visas. E-student visa for eligible international students registered on the Study in India, SII, portal. E-student X visa for dependents of e-student visa holders. Key features and process. Mandatory registration. Students must first register on the Study in India, SII, portal and can apply for a visa only after receiving an admission offer from an SII partner institution. Eligibility. Available for international students enrolling in full-time undergraduate, postgraduate, PhD, or other formal programs at recognized Indian institutions. Duration. E-student visas are valid for up to 5 years, depending on the course duration, and can be extended. Devolution Index. Context. Ministry of Panchayati Raj recently released the Comprehensive Devolution Index report. It is a result of meticulous research and empirical analysis and provides insights into the progress of decentralization across states and union territories. The index evaluates 6 critical dimensions: framework, functions, finance, functionaries, capacity building, accountability of the panchayats. The index specifically examines how free panchayats are to make and implement independent decisions, reflecting the true spirit of Article 243G of the Constitution. Digital brand context. The Ministry of Electronics and Information Identity Technology, MITY, introduced DBM to streamline and standardize the government's digital presence. DBM. About DBM, it simplifies and unifies government websites for better accessibility. Aim. Enable citizens from diverse backgrounds to navigate and access essential government services easily. Significance. Enhances service delivery, ensures uniform messaging across ministries, and increases transparency in government priorities. First Ethics. Context. Vice President Jagdeep Dhankhar gave a committee reference to the First Ethics Committee while expressing his pain over the Rajya Sabha chamber cash incident. About First Ethics Committee 1. The First Ethics Committee, Rajya Sabha, constituted by the chairman, Rajya Sabha, on March 4, 1997, was the first ever ethics committee created by any legislature in India. 2. It was established on the recommendations of the Vora Committee, 1996, which was established to reduce the increasing criminalization of Indian politics. 3. It was chaired by distinguished leader late Shri S.B. Shivan, who hailed from Maharashtra.